Hello, everyone. Welcome to our Wednesday webinar with the Property Law Alliance, and then a very special welcome to Silna and Bruno. Silna, I'm glad that you can join us today. And then how are you guys doing, Silna?
I'm good, thank you. I'm so sorry I missed last week's episode, but thank you so much, Marilee, Bruno, and Greg in his absence for picking up the ball when I can't do a recording. So thank you so much. It was actually a pretty good session. I watched it live, and that was cool. I hope you saw my likes because I liked it the whole time. I was like, yeah, you go, it's awesome. But I'm good. Thanks, Marilee. How are you?
I'm good, thank you. And I'm glad you're back. And then Bruno, how are you doing?
I'm very well. Thank you for asking, Sona. It's good to have you back.
Thanks, Bruno.
Now it's a pity we lose Craig. It's almost like a little juggling act. We can never have all three of us at the same time.
That's exactly, at least you two, you and Marini are pretty much the constants here. So thanks for that.
No problem. All right. So first I want us to discuss, we have a scenario where the intention of the two parties is to conclude a lease agreement for a fixed term period of 14 months. So in the lease agreement, there was a typo. So it had to commence on the 1st of December 2019 up until the 31st of January 2021. That was the intention. However, it was typed as the 31st of January 2020. And now the tenant is packing up. He gave a month notice to the landlord. According to him, it's on a month-to-month basis, the lease agreement, because the fixed term ended on the 31st of January 2020. And the landlord says, no, this was not the intention of the parties. So you have to give me a reasonable, or he thinks that a reasonable cancellation fee is applicable because it's cancellation in the midst of the fixed term period. So I don't know, Bruno, do you maybe want to get started on this one? Maybe just start discussing it.
Awesome. So we actually see quite a lot of these, and that's why this question is so important. I mean, I do it all the time. When you're drafting a letter and it's 2020 and it's the beginning of the year, you're still writing 2019 in that letter. It happens all the time. So as soon as you have to start thinking 1 year ahead or 1 year before, you start getting dates completely wrong. So it's normal because we tend to fall into habits of writing dates, of getting dates down. And so this is actually quite a cool question because you can divide it into two. So the first thing is, what happens when the contract says something that the parties didn't necessarily initially agree to? And what was the intention of the parties? What's the interpretation aspect? What if there's a dispute as to clauses, timeframes, that sort of thing? The second question then comes to a reasonable penalty charge or fee when it comes to early termination. So that's something that we can discuss secondary to this. So from my side, and if I understood the question correctly, basically, it should have said 2021, but it said 2020. And now it sounds as though the tenant is using it to their advantage to get out of the contract before 2021 comes in, when it's actually supposed to be the last month. They're trying to get out now a lot earlier than they were supposed to, and the landlord wants to charge a penalty. So look, first port of call, obviously we need more facts, but first port of call would be to look at the contract, because if there is a typographical error, this is something that can be fixed. So there are principles in our law called rectification, for example, when you can go to court and ask the court to read into a contract in a certain way, because that's what it was supposed to say to begin with, especially when it comes to typos. And if you can prove that that was in fact the intention of the parties, it's not a question of changing the terms of the contract, because the courts hate doing that. It's a question of rectifying something that was supposed to be there to begin with, but somebody messed up somewhere along the way. So in this specific instance, if there's actual evidence that says, look, it was negotiated for a 14-month period, but now the tenant's taking advantage of it, but you can see clearly that that was the intention of the parties, you may be able to rectify the contract, and the landlord would then have a leg to stand on when it comes to early termination. So that's one way of looking at it. The other thing that you'd also need to do is look at the contract, because read the contract properly to see where it kind of leans towards. Because if a contract is a month-to-month, you'll see that there's a lot of clauses that kind of lean towards a month-to-month basis, Whereas if it's supposed to be a longer fixed term period, so for example, when it comes to like a cancellation, early termination penalties. If it says, for example, that a landlord can charge between 2 to 3 months, it wouldn't make sense to me that the contract would be a month to month and it would only have that initial period, because that would kind of go contrary to the way that you're supposed to calculate other things. So you have to read the contract holistically to see also whether the contradictory terms and which one applies. But yeah, I know you, Silna, have also experienced this quite a bit when it comes to, for example, certain legal interpretation principles. For example, the person who drafted the contract has the contract interpreted against them. So there's a whole lot of other principles that one can look at holistically, assuming, for instance, we can't prove the intention of the parties and both parties stand on an equal footing when it comes to month versus long term. There you'd have to really look at the contract and deal with interpretation. So I don't know, what do you think about that? What experiences have you had?
Yes, I think something actually quite similar. I recently had a very similar matter where very similar facts to this, where there was also again incorrect recording of 20 and 21. So, the true to 2020, I think just the number itself is difficult to write. We should have noticed that we're probably going to have a fun year. But same story. But the facts in this matter was just a little different, in that the tenant the tenant was also under the impression that he's on a month-to-month basis. The other way around. Landlord thought we're on month-to-month agreement, and now the tenant trying to hold the landlord to a longer term. So these things happen, and like you rightly say, we do have the right to bring rectifications, and I mean we've all done that multiple times. So just for the benefit of the viewers, how you do a rectification is usually, if it's something that is very obvious, something that you can see from the intention of the parties, this was the intention. So for instance, in this particular case, Bruno, I think you'll agree with me, if there was, for instance, a lease application form, and the lease application form had 13 months with the correct dates, it's a relatively easy rectification. And how you will do that is, in your application, say for eviction, or your summons for claim for rear rent or whatever, you will bring that document in and you will say to the court, this is clearly the intention of the parties to have it as a 13-month agreement from this date to this date, 2021 instead of 2020. And the court will say, okay, yeah, duh, it's obvious, somebody just had the number wrong there. But this is one of the big reasons why we write numbers in words and in numbers. I know people wonder why attorneys does that. And I think people just assume we're that bad with numbers that we have to even bring numbers into words. A little fun fact that could very well be the truth, but I think it's actually even more so. The moment you have a number and the number in words, you will have to go and look at the interpretation clause. So I'm going to use the TPN lease back again as an example. The two most important clauses in any agreement is your definitions clause and your interpretation clause. So for instance, clause 2 and clause 3 of the TPN leaseback, I swear, if I know more than 5 people that's ever read that, I am very impressed, because nobody ever reads that, because it's like, why is this there? But similar to legislation, your definitions clauses are usually the most important clauses, because that is how you interpret the contract. And something, for instance, you were talking about the rule of interpreting a contract against the party that was responsible for the drafting for that. You want that provision excluded in terms of your interpretation clause, especially if you're the person drafting on behalf of the drafting party. So for an attorney, to be quite frank, Bruno, I know this is a bit harsh, but I almost think it's a little negligent not to bring a clause like that in when you're drafting, because you need to protect the client that you are drafting on behalf. If you're drafting There's no way you're going to draft for the party that's not responsible for the drafting. So it's a very important clause to have, and you need an interpretation clause, for instance, stating that if there is a number in numbers and in words, the number in words will take precedent to the number in numbers. So these are the important things. So when you get to a situation like that, we can talk about litigation for days, Bruno, but you and I both have an equal passion for keeping our clients out of court. We only go to court when it's really, really necessary, because we know it's going to end up costing a client a lot of money, wasting a lot of time, and not even to mention the emotions that runs with litigation.
And that's just from us.
That's not to mention our emotions, let's be fair. So it's something very important to keep in mind, because if a contract is not simple enough to, on just the reading of the contract, you can understand what the parties' intentions are, then you run the risk of litigation. So something that you and I discussed just now before we started was the intrinsic evidence rule. So this is a bit of a scary rule. And the long and the short of this rule is, if you have a written contract, only the terms of the contract is relevant in front of court. You don't have the right to bring any evidence outside of that. So as much as we discussed the rectification, if you, for instance, have your lease application form, you can show in your rectification, this is the content of the contract. If you want to bring evidence outside of the terms of the contract, you won't be allowed to do that in terms of our law of contract. However, Bruno, talk to me about that. What's your opinion if there is something, and say we don't have a proper interpretation clause? It's one of those contracts that you read, there's no interpretation clause, there's sort of three clauses.
Serviette contract.
Exactly. So one of those that's like, at the end, this is the whole contract, not sort of a makeshift non-variation clause, and sort of hope for the best match good jurisdiction clause. If that is the case, and you know exactly what I'm talking about. This is just lawyers that would find this funny, I swear.
It's like the most important clause ever. Everything has a jurisdiction clause, one of the most useless clauses, but no, you don't have the important stuff in there.
That's always the way it is. It's 100%. And usually in that match court clause, they limit the jurisdiction of the High Court. So I'm always like, what are we doing, guys? But anyway, that's a side note. I'm sorry. But something very important is, if you're in a position like that and you have a clearly contradicting situation like this, amount of months and then dates, with the intrinsic evidence rule, what is your opinion? Would you be allowed to bring oral evidence to try and resolve that, or even if it's not oral evidence, any other evidence? What's your position on that?
Sure, that's a difficult one.
I know, that's why I asked you.
Yeah, thank you.
Call a friend, get a lawyer.
So look, there's a lot of questions we need to ask the client, because so intrinsic evidence or parole evidence rule, exactly what Silna described, you can't after the fact try and change the terms of a contract to say, look, but it should have said this, or, you know, we missed this component of it. But so for example, stupid instance, if a person agrees to sell a certain object for a certain amount of money, they can't later come and say, oh, it should have been that amount of money plus something else, right? Because it wasn't in there. And the bottom line is, it wasn't an error. It wasn't something that was just missed. It's just not in the contract. And if the other party denies it and said, well, that was never part of the agreement, you can't go to the court and say, but it's only fair because from a value perspective, it makes sense. We had discussed it previously, so it should have been the case. The contracts would, the courts will outright refuse to step into the shoes of a contracting party. They've said it. There's case law all over the place saying we will not interfere. There's case laws, even when it comes to things like evictions, lease agreements, specifying even constitutional issues and public policy. Even there, the courts are very careful because they'll only jump in if it's a public policy issue where they feel, hold on, but we need to intervene because this is really unfair. But unless it's really unfair, the courts probably won't intervene and say, sorry, you contracted, it's, next time negotiate better, get a better lawyer, you got, messed out of this deal. So in this instance, for example, if, for instance, there's an application that proves the 1 year, this isn't where this parole evidence or intrinsic evidence applies, because that's about obvious error. And you can go to court and have it rectified. So that's not what Silna and I are referring to. Let's say there's a proper dispute and there's ambiguity where one party truly believes it was a month-to-month and the other party truly believes it was a year contract. This starts getting complicated because now if there's ambiguity, there's one interpretation principle that we discussed where you interpret it against the person that drafted it. So as a landlord, if you're providing the lease agreement to the other party and they're signing it, and you caused this ambiguity because you drafted the contract and you should have been careful, the court will interpret it against you in favor of the tenant. So that's already now something very big that you as a landlord need to make sure that you're covered, that when you draft the contracts, they actually make sense and that you're happy with them. So that's a very, very big one. I do know of situations where if there's an outright error and it turns out that the contract so for example, if I promise to pay you X amount to buy, stupid example, a very expensive car and you thought I was actually offering to buy your laptop. Outright errors like that, the courts will obviously intervene and say, sorry, there was no meeting of the minds. So unfortunately, there's no simple answer because you need to look at the contract. You need to read through it and you need to see, listen, was this a complete non-meeting of the minds? The parties were completely confused as to what was happening. Or is it just ambiguous? Because then you might want to interpret it in favor of the person who was given the contract and simply signed it. Are there other provisions in the contract that kind of allow a certain interpretation to exist? Because remember, another interpretation principle is clauses shouldn't contradict other clauses. So what we had discussed, for instance, was if it says 12 months and it says that a termination penalty, an early cancellation penalty can range between 2 to 3 months, it's kind of reasonable to think, hold on, but that would never happen if it was a month-to-month lease agreement. So surely by that being in the contract, the parties had intended it to be longer than one single month. So I think the attorney or legal practitioner would actually have to look at it and properly interpret it. But those are just some of the hurdles that one might need to look through, depending on what evidence we have and what the actual story is.
Yes, and I think you make a very valid point. As much as we have the rule of interpreting the contract against the party that's allowed, that's responsible for the drafting. On the other hand of that, so you can contract out of that. I think that's very important to appreciate.
Absolutely, yeah.
You can contract out of that, and like we said a little earlier, you should contract out of that. But caveat subscriptor, which is a principle that says, a direct translation is, be careful when you sign a contract. Be careful when you enter into an agreement like this, because you will be held to the terms of that contract. So I think that's a very important principle to discuss as well, because if we look at these principles, Bruno, I think the most important things that we want our viewers to leave with tonight, if they get into bed, instead of having like horrible nightmares about contracts attacking them. Have you had that one? I've had that one. Contracts attacking
I think we have it as lawyers. I'm hoping our clients go to sleep with other dreams. Okay.
I know this is not a dream show, but I once had a nightmare that I was busy drafting a contract, and the letters actually started coming out of my laptop, and I was like, it was so scary. But I think that's a lawyer nightmare.
Yeah, I had that on trusts, and I couldn't get the numbers right, and the whole night was just about trying to make numbers work and putting the assets in the right place, and it just wouldn't fit. It made no sense.
I'm so glad we're sharing lawyer dreams, lawyer nightmare stories, because I think it's just that. But so if you don't want the letters of your contracts to attack you, what is the practical easy advice that we can give to our viewers. And I think you touched on it just now while you were talking, is first of all, make sure that the content of your contract is simple and clear. Ambiguity, anybody that's ever been in one of my live seminars would know, I always say, I want a tattoo right there on this arm with the word ambiguity, because ambiguity is the reason we lawyers. If it weren't for ambiguity, I swear we won't have jobs, because ambiguity, you have proper, clear disputes, and it's relatively easy to run to court with that and solve it. But these little irritating things that our clients need to deal with on a daily basis, that's not the big disputes. It's not the big problems. It's ambiguity. An ambiguous term in a contract or something like that, and that is the things that's taking hours and hours and hours to resolve, because the one party thought this and the other one thought this. And if we, as the poor innocent legal practitioners, sit and read the contract, you're also like, huh? What was the idea here? And if you, as a party to a contract, if you don't read the contract, I know it's boring, guys, and I know it's going to take you hours to read the thing, and you're going to get very bored and you're going to fall asleep. We are weird, and we can get excited when we read contracts. It's sad, but it's true. We also have nightmares about trusts and contracts, so let's not judge each other here. But if you can't read the contract and explain it to your 10-year-old kid so he can understand it, you're missing the mark. It has to be clear and obvious, especially on lease agreements. I see so often that a landlord had a bad experience in a previous matter, and they try to close all the potential risks by amending their contracts. And they amend it not just in a way that could be illegal, it could just be ambiguous. So on the one hand, you say, whatever, if you damage the walls, then you need to repaint it. And then the next clause says, if you damage the walls, we're gonna cancel the agreement and evict. Okay, so what's the plan? Should you fix it or are you leaving? Ambiguity like that, where nobody can clearly see, if this happens, this is gonna happen. You need to make sure the purpose of a contract is always to set out the rights and obligations of the parties. If the parties aren't clearly identifiable, and if the rights and obligations of the parties aren't clearly defined and attached to a specific party, your contract's not going to fly. It could be legal, it could be enforceable, but it's going to be a pain, because what you want with the contract is on simple reading. Both parties should understand their rights and obligations, and that is how you avoid litigation. You get into litigation when it's so watertight. I hate it when people use the term watertight contract, because there is no such thing. A contract is made of paper and words, and the moment that is watertight, you're doing something funny. A contract can never be watertight. A contract is, yes, contracts are made for divorces. You pull a contract out when there's a problem, but you need to draft it in a way that you don't have to litigate around the problem, but you can read around the problem. Am I making any sense? Do you sort of agree with me on that one,
No,
Bruno?
absolutely. Oh, no, without a doubt.
I think that's the easy, simple solutions that we can give to clients. So don't amend a contract. If your attorney drafts a contract, or you, for instance, use a pre-drafted contract like the TPN lease back leases or the sales pack or whatever, don't amend that. There's attorneys that spend years and years of their lives to perfect contracts like that. And we pull it from a lot of different parts of the law. It's not, there isn't one piece of law like just the law of contract. For instance, when we draft lease agreements, it's law of contract, but it's also rental law, but it's also constitutional law, and it's also law of persons, and in certain elements, family law. There are so many different aspects that we draft into contracts. So don't amend your contract, because you're going to amend straight out of the original intention of the agreement, and don't try to avoid any handwritten components in your lease agreement. I appreciate that lease agreements are very often pre-filled. Rather get it in Word or, well, in PDF even, but type out what you want to type in, because in all fairness, 2020, 2021 or 2022, 2023, you should see my handwriting. Nobody knows what I'm writing. It's really amazing. I got that from my mother. She also has a unique handwriting. But if not everybody has the same handwriting. Marilee has an amazing handwriting. She can write stuff that you can read. But remember, when you start copying a handwritten document, by the first copy, you can't see what you wrote. So I know this is very practical now, and now we're not even having a proper argument. I'm sorry, because I went from argument into practical advice. But I think those are the kind of things that we can give handy tips to our viewers to avoid difficult things like that. What else do you have?
So just to kind of build on what you were saying, so the one thing that I find is when people amend contracts, so what I do with my clients is I try to get them to a point where they don't feel that every time they have to do something, it's a whole new contract, a whole new experience, a whole new like bunch of cash that they need to pay. The reality is you try to set up a continuous flow of things. So yes, invest upfront on making sure things are right. And then in the long term, you just kind of build on what you already have. So that's the first thing people need to realize is you're not drafting a new contract each and every time. You're actually working with existing contracts and building on them. So the problem is when people go and amend their own contracts, right? Unless you know what you're doing. When we amend a contract, and we get this all the time, like just make a small amendment. It's one sentence. Just put it at the end. And it's like the problem is that when we amend, we need to go to the contract. Now, if we know the contract, it's easy because I can just go, oh yeah, I remember I dealt with this at 3.1 and 5.1. I do a quick search. I know what to look for and I know exactly where to find it. But I mean, just stupid things. So like even yesterday, I was amending one of the sale agreements that had an agent. And I was just doing a quick amendment. And even with that, like I almost forgot one of the paragraphs in there that said that no agent was used in introducing this property. And then I was just doing it for an agent where I was including a nice commission clause because he wanted to secure his commission. And you know, if it wasn't for me being methodical and going, hold on, wait, I'm sure there's something else, and finding it, I would have left two contradictory clauses in there saying no agent was involved or agent was involved and that's their commission. You don't want that. And that's the problem is we know these contracts. And if we don't know these contracts, we don't mind reading through these contracts because that's what we do. If we just go out and do an amendment, throw it in the last paragraph, it causes issues because it creates confrontation, it creates contradictions. And then the other thing that really creates contradictions is very broad clauses. And people try to do that because they go, well, if I'm very broad, it covers everything and then I'm protected. But it doesn't, because the broader you go, the more argument could be raised as to that not being the intention of that clause, that wasn't what it was meant to actually cover. So you feel that you covered, and because you're too broad, half the contract contradicts it, which means that it actually makes no sense. When you try and interpret it, you don't know what it's supposed to cover because half the contract doesn't go with it, the other half kind of goes with it, and it creates problems. So just be very careful about being too broad. Try be concise, try be definitive. Know what you're trying to say and explain it, but explain it as a layperson. Explain it like you were doing a story. And sometimes you find those are the best clauses because people read them and go, oh, I understand the person's concern. That's what we need to cater for. Great. I agree with that. I've even done it now in an employment contract that we were drafting for a really good friend of mine. And even there, I told him, you know what, draft your clause. Tell us what you don't like about the current agreement. And we'll just incorporate it in because we can put it in there and just express yourself in a particular way. And I think that's where attorneys do it well because we do that. We check the contract for any contradictions, and then we incorporate whatever you need into the contract into all the right places.
I think, Bruno, I think you summed it up perfectly, but I think to put it in like a proper little bubble would ideally be just trust your attorney. Like we read contracts and we're comfortable with that, and we know what our contracts are. So if you have a good relationship with an attorney, that you know this is what they do, this has been your property lawyer all along, trust us on what we're drafting, because I know sometimes it looks either oversimplified or something that you think, I would have done it differently. Fair enough, there's a lot of things that I think I would have done differently, sometimes from my doctor, for instance. But trust your attorney, and don't try to help your attorney when it comes to contract drafting. Ask all the questions, 100%. But there is a time and a place where you get an attorney, not because you need an expensive friend, but because that's sort of what we do.
All right. Thank you so much, guys. I think that is about the time that we have. So if you have any questions which you want us to discuss or topics for next week, please post it on our page or inbox us. And then have a lovely week further. And thank you so much, Selma and Bruno, for joining me.
Thank you, Marilee.
All right. Okay. Bye.
Bye-bye. Have a lovely week.
Cheers.
Cheers.
Bye.